damage that inequality does is effectively to disenfranchise large parts of our population.
Let's get this clear. We enter on the basis that we are equally meritorious, if not more.
Women are often subjected to critiques always about what they're dressing, what they look like, the size of their behinds, and whether they're good looking or not good looking, as if it made had some impact on their ability to be lawyers.
Not only do we have post-colonial laws from 1876 that haven't been changed, but clearly situations that women are working in as well.
सोसाइटी ने कारपेट के नीचे छुपाया हुआ है बहुत सा गन. वो बताते हैं कि हम चूंकि ट्राइबल सोसाइटी है, हमारे यहाँ ऐसे कोई मसाइल और ऐसे कोई रवैये नहीं हैं.
When they say that appointments are being made on merit, who decides what is meritorious?
Welcome to Schona Jolly QC, who's joined us from England. She's chair of the Bar Human Rights Committee of England and Wales and head of Cloisters Human Rights Practice Group. She brings many years of experience from areas including commercial law, employment law, and human rights. Moving on to Her Honour Judge Khatun Sapnara, also from the UK. She's a circuit judge with the East London Family Court and Kingston Crown Court. She's authorised to act as the judge of the High Court in England as well. Then moving on to Baroness Helena Kennedy of the Shores QC, Director of the International Bar Association and the Human Rights Institute. She's also an author and an outspoken Labour member of the House of Lords. And welcome also to Ma'am Sabira Islam, who was not only the first additional Advocate General of Baluchistan, but is also the first Ombudsperson of protection against harassment at the workplace in Baluchistan. Just putting this session into a little bit of context and thinking about Asma. Asma worked seamlessly on local and global fronts to ensure women's participation in the legal profession, and I think that's why this session is so relevant to us all today at the conference. She empowered women, men, and the transgender to fight against injustice in a space where they had little to no legal representation due to social and financial constraints. So I'd like us to keep all this in mind when we're listening to our speakers today. And in an age of anger where women's rights are under attack on a daily basis across the globe, and xenophobic forces of the extreme right are in government in several countries that we're all working in, I thought that we could also consider certain questions, and I've shared these with the speakers to think about when they talk to us today. So I'll just present these questions to you as well, so you can think about them when you are asked to sort of pose questions to the speakers. So really, firstly, what does it mean to be a woman in the legal profession today? Why are we discussing this issue today? What are the pros and the cons? Does gender in itself imbue women with a special insight into the legal profession? And thirdly, do we forget some of the women who are agents of the cruel patriarchies across the globe, and in fact, even in the legal profession? And finally, as women lawyers, how do we actually strengthen the fight against gender injustice and all forms of injustice within our own profession, as not only as professionals empowering and assisting our clients, but also as people who are upholding the rule of law and challenging a lot of the abhorrent laws that we're working with in the various jurisdictions that we're practicing. So without much ado, I'd like to ask Schona Jolly QC to start off the talk today.
It's really a great privilege to be here. As probably everyone in this room, I was a huge admirer of Asma's work. I met her when I was a very junior barrister working in India at the time, and was really impressed by her ability and the ability of other senior barristers I was working with in India at the time to recognize the fight for gender equality was of pivotal importance to not just half of the population, but the entire population. And when we talk about gender equality, it's very easy to think this is an issue that doesn't refer to everyone. It's an issue that refers to half of us. It's an issue that refers to all of us because we are all human beings and women's rights are human rights. And I want to start with that premise, that if we are in the fight for human rights, we can't pigeonhole women's rights as one aspect of them. They are pervasive and they apply to everything that we look at. Why does it matter to have women in the law? Well, it matters because we have to have a representative society amongst lawyers and judges, so that when we have litigants in courtrooms, when we have litigants who come to us for advice, they are able to recognize in us a reflection of the wider society that we serve. So we don't sit in isolation in the justice system. We have to form part of that wider society. And therefore, women's representation absolutely matters. I come to you from England, where I've been practicing for 20 years. And even across 20 years in the profession in England, the legal profession has changed in terms of complexion, in terms of its understanding, and in terms of its diversity. But we're not there yet. And I want to just say and impress upon you that this isn't an English barrister coming to say we got it right. But what I am saying is that we are on a journey where we are making a difference. And we are beginning to see, albeit far too slowly, senior women, both in the profession and on the bench. And I'm sitting with two of those here. The great damage that inequality does is effectively to disenfranchise large parts of our population. And when you think about gender equality, it's important that you put it in its whole context. Gender equality isn't just about looking at what's happening to women. It's about looking at intersectionality. It's about looking at the rights of women who are disabled, women who come from a minority, women who come from a particular sexual orientation or religion, women of a particular age. And you have to, women of socioeconomic disadvantage. And you have to piece all those bits in the puzzle together to begin to understand what disadvantage really looks like for some aspects of our society. And we in the legal profession are privileged because we are in a position where we may be able to make changes. I'm not saying it's easy or that they come overnight, but we are in a position where we can influence the structures around us. And we need to be there, but we need to be there working in partnership with men and bring men on board with us, just as we need to bring people of all protected characteristics with us to make systemic change in our societies. We also need to think about what equality looks like in our own profession. We can't represent the wider world without reflecting on whether our own society is discriminatory, our own profession is discriminatory. And there are many aspects of that, and I know that some of my colleagues will speak about that too. And in some places, that discrimination is far more rife than others. There's been a recent survey by the IBA of sexual harassment across the legal profession across the world, and the results of that are really striking. And those are the things that we don't talk about in a profession. But there are other more practical things that we need to talk about how we actually get equality in our profession. Some of those are more obvious things. Some of those are mentoring. Some of those are making sure there's space for women as they come through the system. But some of them are less obvious. Those are some of the things that we're thinking about in our own profession in England now. How do I, for example, manage my multiple lives if I'm told by a judge at 4 o'clock in the afternoon that I need to present written submissions overnight, or that he or she is going to hear the case until 6 p.m. when I only have childcare arrangements in place until 5 p.m. Some of these are very pragmatic questions that we need to ask ourselves, and we need to say, why is it that women are not rising through the ranks? They are, but they're doing it too slowly. And the very latest figures from the Bar Council in the UK seem to suggest that the rate of women in the English bar has been dropping rather than rising. Now that feels counterintuitive, because actually if you look at the bar just visibly, the junior bar looks at least approaching 50% women at the junior bar. The question is what happens when they get to the mid to senior parts of the bar. Why are women dropping out? And so many of the practices of the law exclude women in so many subtle and often not so subtle ways. And so we have to think about all of those aspects when we think about how we get the quality in our own profession.
And I'll now move on to Khatunji to tell us a little bit about her own work.
And what Schona has said about the importance of representation and that representation actually matters. It also matters ultimately for the legitimacy of the legal system. It matters in terms of the legitimacy of the judicial profession, that those that serve the public reflect the public that they serve. And it matters in terms of the ability of people to engage in proceedings in a way that they can feel included, that they can give their account unfettered by discriminatory practices and attitudes. And they need to feel heard. And we know as judges that if people feel that they've had a fair hearing, and that takes all sorts of forms, it's not just about giving them enough time, it's about understanding some of the difficulties, whether they have learning difficulties, whether it's women who are of a Muslim background, who have never been exposed in a room full, sometimes, of white men who are undertaking all of the jobs in the courtroom as advocates, as judges, etc. That must be inhibiting for them. And ultimately, if our orders that we make at the end of a hearing are to be respected, we find that if people feel that they have been heard, even if they are orders that go against litigants, they are more likely to adhere to what we order. And actually, ultimately, that is very helpful to the justice system in terms of money and cost and delay. And at the end of the day, in more ways than one, justice has got to be done, and it has got to be seen to be done. So that's part of what I want to say. I'm very reassured and encouraged by seeing so many men in the audience in this particular session. And I want to echo what Schona has said, that, women's human rights are only a subset of human rights in totality, and we can't do it alone, and we need support. It seems to me that I speak to you at a time when we are celebrating in England 100 years, the first 100 years of women being able to actually become lawyers in the UK. And we still have quite a long way to go. There is quite a lot of parity at entry level, and then people fall away. And there is a huge problem, especially at the bar, of retention of women. And usually, after they've had their second child, there is a massive drop-off. And that speaks volumes, really, about the challenges that we face. When Schona said, when judges make unreasonable demands on advocates, not taking into account their childcare responsibilities, etc. And let's face it, and I've got a fantastic husband who's very supportive and in the audience here today, but regardless, generally the primary care task responsibility still falls on women, even if they are professionals. And what we really need is for there to be upward mobility. We need social mobility in terms of making sure people from a disadvantaged background actually manage to access the profession. It's increasingly more expensive and burdensome to do so. But the intersectionality of disadvantages that impacts particularly in England and Wales on actually Muslim, Asian, black and minority ethnic women is very, very significant. And so we need to remove some of the barriers to entry. And once people have entered, there needs to be proper recognition that there are particular challenges faced by women, which are gender-specific, which require proactive support. And we need ultimately, I think, women in leadership roles, because until women are represented, there's no good saying we've got X number of judges, who are women or are black and minority ethnic, because they are usually in the lower rungs and the lower tier of the judiciary. And until we have women in leadership roles who are then in a position to effect change and a change in culture and encourage and support and mentor other women coming through, we're not going to see change, and we're certainly not going to see change, it seems to me, at a rate that is acceptable. And I've got a background as a barrister. I because I could speak English, I was an informal advocate for members of my community before becoming a formal advocate. And I faced, in terms of challenges, first of all sorts of issues within my own minority community, which put in barriers preventing my progress. The very fact of me being allowed to go away to university and to conduct myself in a way that wouldn't bring shame and dishonour to the community at large, let alone my immediate family. And so when I'm in the profession, not only are we competing with men, and let's get this clear, we enter on the basis that we are equally meritorious, if not more. And we progress because we are twice as good, because otherwise we simply don't get noticed and we don't even register on people's horizons. And so we then have to understand what it is that prevents our progress. And it seems to me, in large part, that is because of the traditional patriarchal hierarchies and people favouring people in their own mould. And when you've got at the top of the legal profession or the judiciary usually white men from a very narrow social class who have been public school educated, are wealthy independently in their own right, they tend to recognise you have direct prejudice and you have all sorts of other prejudices that people aren't even aware of. And that definitely impacts, it seems to me, on appointments that are made and progress that is made. And it's really down to all of us together to work together to recognise those structural discriminatory practices and to work to try and eradicate them.
Thank you, Khatun, and I think you brought up some really interesting points that we should also use as part of the recommendations that we're hoping will flow out of this session. And I think it's women like you and Schona in the UK who've not only acted as mentors for women from the Black BME community. I'm not mad about the phrase, but we all use it, because it's important to recognize the discriminatory nature of the profession. And you've also touched upon some of the issues that Helena brought up in her inaugural speech this morning about the role of men and women working together. So Helena, I'd like to request you to address our audience.
I too practiced at the English bar, but I, as you will hear from my voice, I'm a Scotswoman. and so I too was colonized. And when I was a student of law and went down to study law, all my friends, it was very interesting about who one gathered together with. It was a time when there were very, very few women studying law at all because of my great age. And all my friends were what were called Commonwealth students. So all the Pakistani men and the West Indian men and the few women amongst them and the people from all the different parts of the world, whether it was Australia or New Zealand or Canada, all of us who were basically the colonized were there learning English law together. And I think that I learned a lot by sitting alongside people who came from other parts of the world. It internationalized my perspective on the law, and many of my friends came from this part of the world, India and Pakistan, and as I say, other parts of the world that had been colonized by the Brits. And so I come from that position of disadvantage, but I think it gave me a great advantage. The thing about my position now is that I spent my life as a criminal lawyer, and as I practiced at the bar in England, it started off being at a time when there were very few women, it was 6%, and then it grew, and I was already rocking the boat when I was still in my 20s because I contributed to a book called The Bar on Trial. And The Bar on Trial was basically looking at the ways in which the bar was configured in ways that were very old-fashioned, and I wrote the chapter on the disadvantages facing women, that women couldn't get into sets of chambers. When they did get pupilages, it was often with a great deal of problem, particularly if, like me, you were not well connected because you didn't come from that upper elite echelon of society. And then women had great difficulty getting into sets of chambers as a permanent member. And let me tell you, I was complaining, but so were my other Commonwealth friends. So were those who came from backgrounds that were different. And so it was very much a profession that belonged to a very elite class of white men. And even my friends who were from Pakistan and India had difficulty getting pupilages, and they wanted to go back home to practice, but they wanted a period of being in the courts in England and Wales to get a sense of how it all worked before returning. And so we all, I think, faced levels of discrimination, and that, for me, at a very early stage in my professional life, gave me a sense in which these are multiply layered, areas in which people in professions are discriminated against are multi-layered, and that's what this word intersectionality nowadays covers, the ways in which you may be a woman, but let me tell you, if you're a black woman or a brown-skinned woman or a woman of difference in one way or another, then you're going to experience it somewhat differently. So as the Americans would say, it isn't a cookie-cutter way of discriminating, it actually works in different ways for different people. And as it got better for women, often it was privileged women who were getting a good deal, not ordinary women. And so my friends who were, women of colour, would say to me, what was happening to them, and I was saying, don't worry, it's happening to me as well, because I was a foreigner too, because I came from that place north of the border where very, very troublesome people came from. And so we have to understand the nature of law and the nature of those who made law and have made law in the common law tradition, and they were essentially very privileged men. And that has meant that we've had to examine law as we went forward, and I had a sort of somewhat academic bent, and I used to spend time looking at the ways in which I thought law was configured in ways that did present as if they were neutral, but were not really neutral at all. And what we do know is that very much the interpretation of law can very much reflect the attitudes of those who are delivering law. And there was an interesting period then in the 70s, late 70s, when a lawyer from South Africa, Albie Sachs, who became a great judge in the South African Constitutional Court many years later, but he was in exile in England, and he and his family became great friends of mine, and he and I worked together on some work around the issue of women. And what you saw was that at the turn of the century, in that period of the suffragettes, women wanting the vote and so on, when you looked at those women who actually were so courageous and said, we want to study law, we want to get into the universities, we want to be able to vote, when they tried to do that, the judges to a man made decisions in the courts maintaining that they couldn't enter the legal profession. And the women argued, but it says any person suitably qualified can get in, and I'm now suitably qualified, why can't I come in? And they would say the word person does not apply to women. So if we're talking about intellectual honesty and fake news, we saw a lot of it at that time, at the beginning of the 20th century, in the cases that were brought to try to end those exclusionary rules that kept women out of professions, medicine, law, and so on. I now, as I've said, my practice was in the criminal courts, and I ended up doing the sort of cases that traditionally had only been done by men. I ended up representing people in serious organized crime, in cases involving political conspiracies that were alleged, terrorism, because we had the Irish Troubles. I did cases of espionage, and I did official secrets cases involving challenges to the state. And so there were lots of difficulties that I confronted. But nothing was as difficult as the fact that there was still discrimination against women, which meant that I ended up writing about it because it affected the women who were clients and people trying to use the courts. Is it different in other countries? My experience is that these sort of discriminations are being worked out in almost every jurisdiction in the world. And we're getting ahead, we're moving ahead, and it's often, and I'm really saying this, and I said it already today, we can only do this, men and women together, and it actually benefits us all, because it means that law is richer and better for our being active together in making better law. Don't always compare things with other countries, because they're not always exactly the same. We all operate in the common law system, Pakistan's too, and that is an adversarial system. In civil law systems, which are inquisitorial systems, they have professionalized judiciaries so that you can become a judge at 26. You can qualify as a judge in Brazil at 27, and the same in Italy and France and so on. And it's a bit like being a magistrate, but you're on a career path which is not the path of a lawyer. In the common law tradition, it has usually been you're a lawyer for some time and then you move on to the bench with that experience. And so you can very easily get at the sense that there's huge numbers of women judges in other jurisdictions, but actually the real thing to look at is, do they advance into the senior roles and into the positions where law is really made? And that's usually in the senior courts. So you have to untangle some of this stuff if you're looking at other jurisdictions. Canada was a great place to look to for places where law was changed, because they ended up having a significant number of women, a critical mass of women on their Supreme Court. And it really did change law, and many other jurisdictions like that of the UK looked to the decisions in the Canadian courts and tried to persuade our senior judges to take account of those decisions when they were dealing with similar kinds of cases. I know I'm short of time, but I would say this thing. There is a delusion. We had to challenge this business that somehow people will rise in the profession, that somehow women would get to these senior positions. It was all just a process of evolution, like fish growing feet and somehow becoming, that whole evolutionary process that's described on the creation of humanity. All I can tell you is that you have to look at the criteria that are used in determining who should become judges, and ask this question: when they say that appointments are being made on merit, who decides what is meritorious? And if you don't have gatekeepers that include other women, and you always get this business of people appointing other people in their own image and likeness. And so if it's always, I'm afraid, you guys that are making the appointments, you're not going to, find all that women can offer the senior judiciary as appealing. And I'm telling you, most women, by the time they've got to those senior levels, have learned how to not only manage a court, but manage everything else as well. And I would much rather see them moved forward than many of the men who end up getting those positions. Now, I want to say one other thing, which is that, of course, circumstances can be different in different places, but the things that disadvantage women as professionals, and you, like us, are seeing many more women coming into the legal profession, but they're still disadvantaged by the conditions of work, the ways in which assumptions are made that you're supposed to be, long hours, available all time, and so on. And we still know that women are often the primary carers of children and of the elderly and have family responsibilities that don't make all of that as possible. But it will actually advantage the lives of men too, if we could have a better working environment in which we don't expect people to be working in those kinds of ways. So I want us to be looking at the working conditions of lawyers, but I also want us to be looking at the ways in which women are often subjected to critiques always about what they're dressing, what they look like, the size of their behinds, and whether they're good looking or not good looking, as if it made had some impact on their ability to be lawyers. It has to stop. It was really shocking to me to hear the extent to which young women whispered to me that sexual harassment was a problem here in the legal profession. Let me assure you, there's nothing different about Pakistan. That's true in every jurisdiction around the world, but we have to deal with it. And you have to create processes so that women can make complaints, so that somebody can say, listen, Charlie, you can't be doing that, or you can find the appropriate name. Somebody has to be saying, that's not how we treat our colleagues who are female professionals. So you men have a responsibility to come out and do this with us, making the change that makes it possible to have a better legal system. Thank you.
You raised some really interesting issues about what we do in a post-colonial situation. Not only do we have post-colonial laws from 1876 that haven't been changed, but clearly situations that women are working in as well. And just generally, in terms of working conditions, You made me think of a conversation that I had with Justice Leela Seth, who is the first woman Chief Justice in India. And I wasn't sure if I was going to share this with you, but she wrote in her, she passed away last year, but she was a guiding light for many young women lawyers across the world and in India, where she narrated, one day in court, I was intently reading a judgment which had been cited by one of the lawyers appearing in a case. I heard some shuffling of feet and the soft murmur of many voices. I looked up and found the courtroom absolutely packed with dozens of people standing everywhere staring at me. I asked my reader whether any specially newsworthy case had suddenly been assigned to me. He replies, "Oh, no, the crowd is a group of farmers whom Prime Minister Charan Singh has invited to Delhi to see the sights. They have just visited the zoo, and now they have come to see the woman judge in the Delhi High Court." Now, this was 1978, but Leela Khala before she passed away, said that it hasn't changed all that much. So with that in mind, I'm going to request Sabira to tell us a little bit about her work in Baluchistan, which is a jurisdiction that I don't feel we talk about enough in Pakistan. And she's not only going to talk about her career, but also about women's rights, which she's had a focus on. Thank you.
बलूचिस्तान के बारे में मैं आपको बताऊं कि बलूचिस्तान एक तवील रकबे पे फैला हुआ सूबा है और जिसमें फार फ्लंग एरियाज़ हैं और जहाँ पर तालीम जो है निस्बतन पाकिस्तान में सबसे कम है और फिर ख़वातीन जो लोअर पार्ट ऑफ सोसाइटी हैं उसमें और कम है। आपसे एक छोटा सा वाक़या सिर्फ शेयर करूँगी चूँकि इंसानी हकूक़ की तंजीम से भी वाबस्ता थी। तो बलूचिस्तान के करीब के एक गाँव कोयटा से निकल के कहीं एक गाँव में मैं गई तो वहाँ पर जो है ऐसे ही मैंने डोमेस्टिक वायलेंस और हैरेसमेंट एट वर्क प्लेस और दीगर ख़वातीन के जो कवानीन हैं उनके लिए ज़िक्र करने के लिए ख़वातीन को इकट्ठा किया। तो वो ख़वातीन मेरे पास बैठी, मेरी बात बहुत गौर से सुनी। फिर उन्होंने मुझसे कहा कि जो है हमें इस तरह के किसी जो है मसाइल का सामना नहीं है। उन्होंने पानी की बोतल मेरे सामने रखी, वो जो मिनरल वाटर था, और साथ में गदला सा पानी का गिलास सामने लेके आई। उन्होंने कहा हमें पीने का साफ़ पानी मैसर नहीं है, हमारे पास सेहत के जो है सहूलतें नहीं हैं, हमारे पास तालीम की सहूलत नहीं है, हमारे पास स्कूल कॉलेजेस वग़ैरह में जो है टीचर्स नहीं हैं या वॉशरूम नहीं है। तो कहने का मतलब ये है कि एक ऐसा ख़ित्ता जहाँ पर बुनियादी इंसानी हकूक़ जो है अभी तक मैसर नहीं है, वहाँ पर एज़ अ लॉयर जो है हम काम करती हैं। मेरी बहुत सी साथी हमारे यहाँ पर आई हैं। तो कानून की नज़र में तो जैसे हम सब जैसे स्टूडेंट ऑफ लॉ हैं, हम ये समझते हैं कि जो है कानून तो यही है कि कुछ ज़ाब्तों असूलों का नाम है जो डिटरमिन करते हैं कि हमारे राइट्स क्या हैं और हमारे हकूक़ क्या हैं। इनके मजमूए को जब हम कानून कहते हैं और फिर कानून का मजमूआ आइन कहलाता है। इस कानून में कहीं पर भी कोई डिस्क्रिमिनेशन नहीं है। अगर हम ये समझते हैं कानून फितरत में कहीं डिस्क्रिमिनेशन नहीं है, कानून नेचर ऑफ लॉ में कोई डिस्क्रिमिनेशन नहीं है, ये जो इंसानों के बनाए हुए कवानीन हैं इनमें डिस्क्रिमिनेशन छुप छुप के कहीं ना कहीं रखी हुई है। अब हम जब लॉयर्स प्रैक्टिस में आई हैं, मैंने जब अपनी प्रैक्टिस जब मैंने वकालत पढ़ी उस वक्त मेरे साथ 20 स्टूडेंट्स फ़ीमेल लॉयर्स थी। जब प्रैक्टिस में मैं आई तो मेरे साथ 4 फीमेल लॉयर्स सिर्फ प्रैक्टिस में आई। वजह जो है वो मैं फिर आपको आहिस्ता आहिस्ता बताती जाती हूँ। फिर जब प्रैक्टिस में मैं आई और मैंने जो है अपने सीनियर्स को भी और जूनियर के साथ भी हमारा एक ग्रुप बना तो अंदाज़ा हुआ कि वो वर्क प्लेस हरासमेंट है, हमारे हर जगह में है, सोसाइटी के हर शोबा है में है, लेकिन हमारे इस प्रोफेशन में भी इसकी बहुत बड़ी एलिमेंट मौजूद है। वो हरासमेंट को फेस करके हम अपनी घरेलू जिम्मेदारियों से जब निकलती हैं ख़वातीन तो मर्द हजरात नहीं समझते हैं। हम एक मदर भी होते हैं, हम एक जो है बहन भी होते हैं और हम एक बहू भी होते हैं। उन तमाम जिम्मेदारियों की खलीज को पार करने के बाद जब हम किसी प्रोफेशन को ज्वाइन करते हैं उस बर्डन के साथ, तो वर्क प्लेस पे हमको मर्द जो है फॉर ग्रांटेड सम टाइम लेते हैं। मैं सबको नहीं कहती हूँ, हमारे बहुत से साथी कन्वर्टेड हैं, हमारे हकूक़ के लिए जद्दोजहद करते हैं। ये बहुत से कवानीन जो हैं हरासमेंट एक्ट بھی جو ہے نا میرے سینئر جو ہیں کیلاش سر کی جو ہے مرہون منت ہے. تو میں یہ سمجھتی ہوں کہ تمام نہیں لیکن سوسائٹی کی میجورٹی جو ہے وہ ڈسکریمنیٹری سوچ رکھتی ہے, اس میں خواتین بھی ہیں. وہ خواتین بھی جو ہے جو اپنے آپ کو مردوں سے یا کسی اور سے کمتر سمجھتی ہیں یا خوف کا شکار ہوتی ہیں یا وہ ان رویوں کی سے دل برداشتہ ہو کر واپس اپنے گھروں میں بیٹھ جاتی ہیں. تو جب میں یہ سمجھتی ہوں کہ ہمیں جو ہے بہت سے, جب ایک شعر کے ساتھ فیض کے اس سے کروں گی کہ چھوڑا نہیں اپنوں نے کوئی نو کے دشنام, زہر سے بجھے ہوئے تیر, چھوڑا نہیں اپنوں نے کوئی نو کے دشنام, چھوٹی نہیں غیروں سے کوئی طرز ملامت, پر اس عشق نہ اس عشق پہ نادم نہیں, پر اس دل پہ سبھی داغ ہیں بجز داغ ندامت. تو ہر طرح کے ایلیگیشن آپ پہ لگتے ہیں, آپ کو ٹانٹنگ کرتے ہیں, آپ کی باڈی پہ, آپ کے روی, آپ کی جیسچر پہ. وہ سمجھتے ہیں کہ جو ہیں آپ اگر وہ جیسے بات ہوئی تھی کہ ہم کسی کے ساتھ فرینک ہو کے بات کرتے ہیں یا کسی سے کوئی مسئلہ ڈسکس کرتے ہیں تو وہ سمجھتے ہیں کہ یہ ان کے درمیان کچھ ریلیشن چل رہے ہیں, یا وہ سوچ جو ہے وہ جو بیمار سوچ ہے ہماری سوسائٹی کی وہ یہ سمجھتی ہے, میں یہ سمجھتی ہوں کہ وہ جو سوسائٹی سمجھتی ہے کہ وہ ایک جو ہے اس سے آگے نہیں نکلتے. اگر میں کھل کے بتاؤں تو سیکشول اس سے آگے نہیں سمجھتے, کہ ایز اے انسان ہم کو نہیں سمجھتے, کہ ہم ایز اے انسان سوچتے ہیں, ہم ایز اے انسان فیل کرتے ہیں, ہم ایز اے انسان سوسائٹی کے لیے اچھے کام کر سکتے ہیں. تو یہ بچیاں جو ہماری آتی ہیں لاء پروفیشن پہ, ان کو سب سے پہلے تو یہ کہنا ہے کہ وہ اپنے ذات کے حصار سے نکلیں, فریب ذات سے نکلیں, جہاں کے سانحے دیکھیں, حقیقت منکشف ہوگی کبھی تو آئینے دیکھیں. تو یہ سوسائٹی میں جو برائیاں ہیں, جو ناہمواریاں ہیں, اس پر کام کریں, اپنی ذات سے نکلیں, کیونکہ ہم سب کے مسائل تقریباً تمام دنیا میں ایک ہی طرح کے ہیں. ہم تمام خواتین ایک ہی طرح کے رویوں کا سامنا کرتی ہیں, لیکن ہم نے اس سے فائٹ کرنی ہے, اس پر اوور کم کرنا ہے, ہم نے آگے بڑھنا ہے, ہم نے اپنے فیوچر کے لیے, اپنے آنے والے کل کے لیے, اپنے بچیوں کے لیے کام کرنا ہے, ان کے لیے راستے ہموار کرنے ہیں. جب میں بلوچستان کی پہلی ایڈیشنل ایڈوکیٹ جنرل بنی تو میرے ساتھ 5 کے قریب میل جو ہے ایڈیشنل ایڈوکیٹ جنرل کام کر رہے تھے, اور میرے لیے انہوں نے جگہ بھی نہیں چھوڑی, کوئی اپنا آفس تک نہیں دیا. ایک آفس میں ساتھ میں انہوں نے مجھے اکوموڈیٹ کیا, اور ان کا خیال تھا کہ جو ہے یہ خواتین جو ہیں ٹائم پاس کرنے کے لیے آئی ہیں, یا کسی سفارش سے یا کسی اس سے آ کے یہاں پر لگ گئی ہیں, کام نہیں کر پائیں گی اور چلی جائیں گی. لیکن 2 سال تک میں نے سرو کیا, اور 2 سال تک میں نے ایز ایڈیشنل ایڈوکیٹ جنرل کام کیا, اور بتایا کہ ہم کام کرنے کے لیے آئی ہیں اور کام کرتی ہیں. پھر اس کے بعد جو ہے میری اپوائنٹمنٹ ایز اے محتسب ابھی ہوئی ہے اینٹی ہراسمنٹ ایکٹ کے تحت. اور یہ کہ پہلے تو یہ تھا کہ سوسائٹی نے کارپٹ کے نیچے چھپایا ہوا ہے بہت سا گند. وہ بتاتے ہیں کہ ہم چونکہ ٹرائبل سوسائٹی ہے, ہمارے ہاں ایسے کوئی مسائل اور ایسے کوئی رویے نہیں ہیں. لیکن اب آہستہ آہستہ میرے پاس کیسز آنا شروع ہو گئے اور شیئرنگ ہوئی, تو اندازہ ہوا کہ جو کارپٹ کے نیچے بہت گند ہے, اور خواتین خاص طور پہ ہر جگہ پہ ہر ڈپارٹمنٹ میں ہراس ہوتی ہیں, اور جو ہے اس طرح کے نیگیٹو جو ہے ان کو ان کا سامنا کرنا پڑتا ہے. تو میں یہ سمجھتی ہوں کہ جو بھی خاتون یہاں پر بیٹھی ہے اور جو بھی رول وہ پلے کر رہی ہے وہ قابل تحسین ہے, کیونکہ اس نے سوسائٹی سے لڑ کے, پہلے تو اس نے اپنی ذات سے لڑ کے آگے بڑھی ہے, اور اس نے سرو کیا ہے انسانیت کے لیے, سوسائٹی کے لیے. ہم انسان جو ہیں اسی لیے اشرف المخلوقات کہلاتے ہیں کہ ہم اپنی ذات سے نکل کر دوسروں کے لیے کام کریں, اور اپنے لیے اور دوسروں کے لیے راستہ ہموار کریں. تو thank you.
You brought up some really interesting points about contextualizing Baluchistan within the broader Pakistan framework and the additional issues that you face as a woman practicing in a state, in a province where perhaps there's the least education and very poor conditions for women. But at the same time, while there are the differences in the jurisdictions, you also brought up so many points that our other speakers have raised, and perhaps we could use those in the recommendations. Just before I take the questions, and I will be coming down to you to the floor, but just in terms of workplace harassment, all our speakers have spoken about not only sexual harassment, but other types of harassment in the workplace, and the other roles of women beyond their legal professions that they take on a day-to-day basis. How do we keep these in mind and incorporate those into workplace policies and beyond? And women discriminating against each other, and that just goes again to one of the points and questions that we brought in the first place, is these structures of patriarchy often force women to sort of replicate structures of discrimination. So perhaps these are issues that can be raised during the Q&A.
You are a criminal lawyer in England. So England is a postmodern country in our thinking. A postmodern, post-civilized. The better word is civilized, I think. So there are a lot of crimes. It's shown you are also a criminal lawyer. So what is the difference and what are the causes? Main question is the causes of crimes are there. Which causes, number one? And what is the ratio of the crimes about women in England?
The majority of crime is committed by people who are wanting to make financial gain. Most crimes are committed wanting financial gain. And sometimes in Britain, I mean, what we've seen is a large increase in the number of people who are committing those because they have drug problems or because they're selling and so on, trading in drugs. It's become a serious issue for us, and it has multiplied the number of people in prison, undoubtedly. Women make up a very small percentage of the number of people who commit crimes inside our system, and they commit crime at a very low level. But they're incarcerated in ways that I find highly questionable. Often judgments are made about women which draw in whether they are behaving as appropriate women should behave themselves. And so there's almost a double burden for women when they come before criminal courts, that they've offended against society's ideas of how women ought to behave. Is she a good wife? Is she a good mother? All those sorts of things are unspoken almost, but inside the judgments that are being made. So all I would say is that most crime, comes out of the divisions in society between those who have and those who have not. And the other thing that happens in Britain is that, and I think that we've seen happening, is that we've been copying America in incarcerating people far too much. Instead of going down the road of the rest of Europe, where we are, we win this league table of being the people who imprison people most. And it's a shocking thing, and it's about turning law and order into a sort of competitive drive between the political parties, who can be tougher on crime, and it doesn't work. So I'm a very strong advocate of looking for alternatives to the use of imprisonment.
My name is Sabahat. I'm a practicing lawyer in Lahore. I wanted to ask, what is the mechanism which is there in your countries regarding the sexual harassment causing women? Because we have a law, but the bars are reluctant to implement that law. So what is the mechanism at your level through which you can prevent sexual harassment, or you can, or the men are accountable to that?
So we have a number of different provisions for sexual harassment. There's obviously criminal provisions, but in the civil law we have provisions for harassment within a fairly broad context. So we have provisions for harassment within employment. We have provisions for employment in goods and services, provisions for harassment in goods and services, and also in education as well. So they form part of what we call the Equality Act, and harassment is just one definition, one aspect of 4 different types of discrimination that you can have. We also have something called the Protection from Harassment Act, which also allows for civil prosecution of harassment, so that if you have a case that doesn't fit neatly within the areas of employment, etc., you can still bring a civil suit for harassment. So there are a number of different ways in which it can be dealt with.
Younger women really have far more tools at their disposal because of their access to and use of social media. And social media is a very potent force for exposing this sort of behaviour, gathering support relatively quickly, and even if people are not named, the public shaming of what has gone on, raising consciousness around it, gathers a movement. And now that we have actually got proper infrastructures in place to deal with proper grievance processes, that all combines to make it more accessible in terms of effective remedies.
कबैली निज़ाम है, वहाँ पे वो घर के अंदर ही उनको जो है ना मतलब कि वो रोक दिया जाता है कि अब यही आपने बाहर नहीं निकलना और ये बात हमारी घर की जो है ना वो बाहर लीक आउट नहीं करनी वरना आपकी जान को ख़तरा है। तो अगर ये स्पीडी मतलब कि ये होगा, इनके मसाइल जो हैं सॉल्व होंगे और आपका काम ज़्यादा रिपोर्टेड होंगे केसेस, 8 की बजाय 10 होंगे, 10 के साथ फिर 20 होंगे, तो इंशाअल्लाह ताला इसमें ये करें कि इसमें जजेस की भी तादाद को बढ़ाया जाए।
अप्रैल में मैंने अपना चार्ज संभाला है और जैसे कि आप समझते हैं, जैसे मैडम ने भी बताया कि कबायली सेटअप है और फैलाया ये गया हुआ है कि चूंकि ऐसा कोई बुराई या जुर्म हरासमेंट एट वर्क प्लेस जो है वो नहीं है, लेकिन ये कि अप्रैल के बाद मेरा जो ऑफिस ने काम शुरू किया तो 10 के करीब केसेस मेरे पास आए हैं और जिसमें 2 केसेस तो वो जो है आपस में कंप्रोमाइज़ हो गए। आ गया केस मेरा, फिर ये कि टाइम उनको जो है डिफेंस का दिया गया, शो कॉज देने के बाद जब टाइम दिया डिफेंस का तो आपस में ही उन्होंने कोई कंप्रोमाइज़ कर लिया और विड्रॉ कर लिया केसेस। 2-3 केसेस जो हैं वो मेरे पास पेंडिंग हैं और वो प्रोसीड हो रहे हैं, लेकिन अभी चूँकि बिल्कुल इब्तदाई स्टेज है तो केसेस आना, जो अवेयरनेस का अभी तक मामला पेंडिंग है, क्योंकि सबसे पहले तो अवेयरनेस होना बहुत ज़रूरी है। सेक्रेटरीट में मेरा ऑफिस है, पूरा अलग से डायरेक्टरेट बनाना है मैंने और फिर काम करना है। तो अभी जो है नवंबर में मैं अवेयरनेस प्रोग्राम तरबियती अपने तमाम तालीमी इदारों में, सरकारी नीम सरकारी इदारों में करने जा रही हूँ ताकि पता चले कि हरासमेंट है क्या चीज़ और ये केस की सज़ाएँ क्या हैं और ये कि सोसाइटी से इसको कैसे ख़त्म किया जा सकता है। लॉ जो था 2010 में पास हुआ और 9 साल के गैप के बाद चूँकि मेरी अपॉइंटमेंट हुई है तो अब जाके इम्प्लीमेंटेशन वहाँ पर स्टार्ट हुई है, तो 10 साल का 9 साल का एक गैप है। तो इंशाल्लाह ताला जो है इसको इस कानून पे अमल दरामद करने की जो है ना अपने ऑफिस को स्ट्रेंथन करके और इस हरासमेंट को ख़त्म करने की कोशिश की जाए।
I studied here law in Pakistan and as a subject we had UK law. So we studied the Equalities Act. But in the Equalities Act, the sections defending sexual orientation were scrubbed off, I believe, while teaching us. So please, will you elaborate the defenses or the protections there are for LGBTQI people in your country?
The Equalities Act is very clear that there are certain protected characteristics and there mustn't be discrimination against people in any facet of provision of public services, in the professions, in any aspect of our society. And it's based on sexuality. And it means that people who are lesbian, gay, homosexual and so on should not be discriminated against in any way. Now, I want to mention this because I know that then of course it was blackened out when you were being given those lessons. I want to say something that's really important, but it's sensitive, I know. I know that for many people, because of their religious observance, they find difficulty in accepting aspects of contemporary positions on homosexuality. The International Bar Association has passed a resolution. Please, I would really like you all to know this. Passed a resolution which was with great care, and it was based on real research in that where there is criminalization of homosexuality, it leads to terrible persecution in civil society as a whole, discriminations of all kind, and it's because of the state sanctioning of criminalization of acts between same-sex persons. And what I want to say to all of you is we are campaigning at the International Bar Association against the criminalization of homosexuality. Whatever your moral position or your religious position, this is different. This is about criminalizing other human beings because of who they are. And I want to just mention that the research that was done showed that terrible abuse of people because of their sexuality is somehow permission is given to it by virtue of the laws that criminalize. And do you know who introduced them? The British as colonizers. We introduced that law into your system. We introduced it in the West Indies and in Africa and in India. We introduced it everywhere. There's no laws against homosexuality in Latin America. There's no laws against homosexuality in large tracts of the world where we were not the colonizers. It was a British thing, and it was about British Puritanism. And I just want you to say, that isn't to say that, you know, people might not have different positions in other parts of the world. In Latin America, they're, I'm sure, no more enthusiastic about homosexuality than in many other places. But they don't criminalize it. And the criminalizing of it leads to persecution. And any of us who care about human rights and the respecting of other people should not want there to be persecution or happening within our societies and deep discrimination. And so I urge all of you to consider that carefully. I would like to see Pakistan at some stage making a decision that criminalizing of homosexual relationships, what people do in their own private lives, is their affair, and it shouldn't be the subject of criminal law. And that's my final word on it.
I've been told by my rapporteur and my timekeeper that we have to wrap up. So what we will do is I'm going to be speaking to our speakers and gathering together some recommendations as a whole from this session. But really, let's take away with us the four incredible and interesting careers from leading, and I don't even want to say women lights, but leading legal professionals from whom we can learn a lot. Again, I'd like to reiterate that harassment in the workplace, the roles of women outside their legal professions, and general workplace improvement have really come out from all four of our speakers' speeches. So those are the thoughts that I'm going to carry with me as well, but just wanted to thank Helena and Sabira, Schona and Khatun, thank you. They had to run off to other speaking engagements, and thank you all for being such an interactive audience.